They're all here. Everybody ready? They're all here.
Yes. Yes, Mr. Adams.
My Lord, I'm grateful for just a couple of minutes to summarise the position. In relation to the limitation point, we say, firstly, it was premature for the judge to even attempt to determine the issue.
Yes.
We also say he went wrong as a matter of principle. Firstly, he was wrong to find that the Crown benefited presumptively from the very short limitation period. You see in particular paragraphs 79 and 103 of his judgment. We, having applied a presumption, it is a different point that he then considered it was for Solaria to put forward what he described as a good reason for the delay, 74, that has echoes of the punitive approach in Cowan, which was rejected. We also say he allowed policy considerations to enter into his reasoning. See the last sentence of paragraph 107. And we then say there are a number of factors identified in my skeleton argument which we say he got wrong in the exercise of his discretion. It's not obvious what the evidential difficulties would have been, and not least because the court would have to just consider what would have happened in the hypothetical world as against what actually happened, and if it would be for the defendant to raise and prove it could have lawfully introduced a new proposal before the 31st of March, and that would be a live issue in the case. And for reasons explained at 106, in Breyer at first instance, we say it would not have had any significant effect on the claim. And as on the novus actus interveniens point, it's difficult to see as a matter of logic how it can be said that the entirety of Solaria's damage was caused by something other than the proposal. And more generally, we say that, with respect, that the learned judge's approach was at odds with the legislative purpose of the provision, which is to provide domestic remedies to the victims of actions which would be attributed to the state and regarded as an interference with fundamental rights under ECHR jurisprudence.
Well, that's the premature point.
My lord, it's slightly different from the premature point.
It is that because if there was a claim that he interfered with by dealing with it when he did, it was premature.
My lord, I think there are two heads to the premature. One, he should have at least had pleadings and disclosure before considering whether there was sufficient prejudice to prevent a fair trial, so as to ascertain what evidential prejudice there was, if any. And secondly, we say the starting point should have been to have left it to trial. But in any event, we say these are in the manner of tortious claims, and a good starting point would be 6 years. Because the issues that arise are no different to the issues that would arise in private proceedings.
And you have to say tort because you're out of time contractually. It's quite unusual if you've got a contract to say, well, it's akin to tort.
Well, my lord, this would be an unlawful interference with the contract.
Well, I understand that. But
which would be a
the
tortious
background
claim.
is still contractual.
Our claims against GBBS were contractual.
Yeah. I mean, the claim arises because there's a contract, which you say then, as a result of the government action, then became worth less.
Yes, and we say it was government wrongdoing, or the wrongdoing by the officers of government, because government cannot do anything wrong, if it was tortious, and they're unable to prove that they had a lawful basis for what they did, that caused us a wrong.
Yeah.
So it is tort, and it's tort from the date of damage, and we were well within that.
So is that your summary on limitation? Do you want to add anything on the...
My lord, no.
Thank you very much indeed.
Grateful, my lord.
Thank you.
Subject to court, I propose to take my submissions in 3 parts. I'll deal first briefly with the factual background, then I'll consider the law and the grounds that relate to the A1 P1 issue, and then I'll consider the law and grounds that relate to limitation. Before doing so, I just make this observation, if I may. As your lordships know, the appellant needs to succeed on both limbs for this appeal to have any impact on its claim.
Yes.
As we made clear to the judge, and as I make clear to this court now, in many ways, limitation was and is our primary basis for the strikeout summary judgment application. We submit that that limb of the application stands strong, indeed unanswered, by my learned friend, either before the judge or before your lordships, whatever view this court takes in relation to the much more difficult issue of possessions.
Yes.
My lords, the facts, the judge's account of the relevant factual background is very clear and full, and I don't intend to repeat what he has said in the judgment. What I want to do is just emphasise a few points that are relevant for the purposes both of the limitation argument and also, to an extent, to the possessions argument. And it's convenient to take the factual background in two parts. First, the background as to what the department did. The second, the background as to what the claimant did. So in relation to the background as to what the department did, the judge considers that in paragraphs 2 to 4 of his judgment. And as he there points out, and as your lordship and your ladyship know, the proposal was challenged in the Friends of the Earth case. Let's give the court the reference. That's Authorities Bundle 2, tab 25. There's no need to turn it up, but it's important to note that Miss Justice Mitting, when finding that the proposal was unlawful, reached that conclusion for two bases. First, if it was implemented, it would have been inconsistent with the statutory purpose behind the Energy Act, and if it was implemented, it would be inconsistent with the prospective nature of the statutory scheme under the same Act. What the Secretary of State did was then to appeal.
So those are the two.
Those are the two limbs
Right.
before the judge, my lady. That was
Inconsistent
first limb
with the
was
statutory purpose, and the second limb.
was effectively prospective, was inconsistent with the prospective nature of the statutory scheme. The first limb was Section 41 of the Energy Act, and the second limb was Section 42 of the Energy Act. The Department appealed. The appeal was rejected on the 25th of January 2012. Not, in fact, 26th of January as recorded by the judge, but nothing turns on that one day. The Court of Appeal rejected the Secretary of State's appeal, but for reasons that were different to those of Mr. Justice Mitting. And the Court of Appeal decision is in Authorities Bundle 2, tab 26. And in its judgment, as my Lady Justice Rose rightly pointed out, with respect, the court found that it was the retrospective nature of the proposal, if implemented, that was the vice requiring it to be struck down. And importantly for our purposes, the Court of Appeal acknowledged that the department could lawfully have proposed a change to the tariff with a reference date after the end of the consultation period, but before the 1st of April 2012. So effectively it was just the retrospective nature or the vice of the proposal having a date before the end of the proposal and of coming into force of any relevant statutory instrument.
Before the end of the consultation.
Yes, my lady, I apologise, yes. For the end of the consultation period, that was and also the relevant statutory instrument would then have to backdate the new tariff. And that was what the Court of Appeal said would have been unlawful. But Lord Justice Moses, at paragraph 50, said that there is plainly power by modification of the original modification to vary fixed rates in respect of installations which become eligible only after any modification comes into effect. Why does this matter? This matters because the 30th of March 2012, being the last date under the existing scheme, is not the be-all and end-all. Why? Because, as in fact happened, the department was entitled to propose a different reference date, and indeed did propose a later reference date of the 2nd of March 2012. It did that in parallel and consulted in respect of that change in parallel to the proceedings that were on foot by then, the Court of Appeal. That actual modification had the effect of altering the rates in the tariffs from the 3rd of March 2012. And that revised proposal takes effect.
And that was after the consultation period.
Absolutely. Yeah. So there was a different consultation period launched in parallel to the Court of Appeal hearing. Yeah. And that revised proposal, which in various places is called the actual modification, has not been challenged as to its legality. Moreover, the claimant, or the appellant here, does not plead or contend that the revised proposal was unlawful.
So the date was brought forward from the 1st of April to the 2nd of March. Lawfully, we assume.
Yeah, absolutely. As one would expect, there was widespread publicity given to the proposal, to the challenge, and the success of the challenge. And if the court could take up the call bundle, please, and turn to tab 12, the court there has the claimant's particular claim. And I'll come back to them when we come to look at the claimant, but for present purposes, I'm interested in paragraph 28 of the particulars. Page 111. And what paragraph 28 makes clear is that at all material times, Solaria and GBBS were aware that the lawfulness of the proposal was being challenged in such proceedings. And the claimant then pleads, for example, at paragraph 43, the dismissal of the appeal, and at paragraph 44, the dismissal of the application for permission to appeal to the Supreme Court. So there can be no doubt but that the claimant was well aware of the fact of challenge to the department's approach. Then, as my Lord Justice Coulson knows particularly well, the department's mauling continued. It continued by having to face a host of claims brought by a very large number of claimants. By the time the proceedings came by way of trial of a preliminary issue before my Lord Justice Coulson, there were 20 different claimants. Some were party to the same set of proceedings, others commenced their own separate proceedings. All brought claims for damages under A1P1, all had slightly different business models and relied on slightly different forms of claim. Those claims were in practice consolidated before my Lord, and my Lord delivered his judgment on those preliminary issues on the 9th of July 2014. And we'll look at that judgment in a little more detail in a moment, but just the court's note, that's Authorities Bundle 2, tab 30.
So despite the overlap, there wasn't any group litigation order or anything of that kind?
No.
They divided into blocks from recollection.
Yeah.
So I think there were three, I vaguely remember, three different blocks of claimants. So, and so therefore three different leading counsel.
Yes, but those...
I've tried to block it out.
No, absolutely. Well, I became involved in the case after the Court of Appeal judgment.
Oh, you missed the best bit.
Absolutely, and I had the as my Lord Justice Coulson pointed out, the unappetising task of having to take those remaining claims to trial. And the remaining claims were complicated factually by reference to each of the individual claimants, there were overarching issues that the department ran as to, for example, justification. But my Lord Justice Coulson is quite right. The issue of justification needs to be determined by reference to each possession. So the evidence that is adduced comes, or was to be adduced, came from a number of, or two particular civil servants. But the evidence would need to be applied to the particular cases of each of the individual claimants. There were expert evidence, and there was a large amount of material that needed to be waded through. Just to assist the court, there is a useful chronology of the proceedings, which is attached to Mr. Olson's witness statement, and it's in the supplemental bundle, tab 2, page 22, and that was produced by the department. There is also a chronology in the call bundle, that's at call bundle 6, page 64. My learned friend in his skeleton argument inadvertently suggested that it's our chronology, it's not, it's his, or it was a chronology attached to correspondence received by the department from the appellant's sisters. But what it's important to bear in mind is that the preliminary issues judgment decided by my Lord and then by the Court of Appeal determined certain issues which then needed to be applied to the underlying facts. And the parties specifically reserved to themselves the right to challenge at any full trial any assumed fact, save insofar as that assumed fact was in that party's favour. So the preliminary issues judgment provided a legal framework within which the court was to be required at trial to consider the actual facts that were then to be presented.
So in fact, one ended up with the same kind of position as if you had had a group litigation order and then a trial for, an order for trial of the common issues of law,
yes,
with the factual application then kept in reserve for when those issues of law had been determined.
Yes, my Lord. There were assumed facts that needed to be agreed or ordered by the part or by the court for the purposes of determining those legal issues. But your Lordship's absolutely right.
Yes, thank you.
The trial was due to be heard for 3 months in January 2018. The trial didn't happen. Instead, the claims were settled or discontinued right up until the moment almost before the trial, in fact, actually started. And it would have been a nightmare to fight the trial, but the department settled the claims instead. But that's what, my lady, that's what I say about the background to the department. As to the background to the claimant, one can take this relatively speedily from the particulars of claim themselves, and it is important for present purposes to see exactly how the claim is put. And one can start with paragraph 12 of the particulars. The claim relates to a subcontract for the design, labour, plant and materials required for the manufacture, assembly and delivery of PV panels and associated accessories, so that GPBS could install those products on residential and commercial buildings in Northumberland. So, pausing there, one sees that there's a subcontractor. We see that there are solar PV panels which would readily be recognised as being possessions for the purposes of A1P1. But the claim is brought in relation to a contract for the design, labour, plant and materials required for someone else then to install the products. It was also an umbrella contract. What do I mean by that? I mean, if one looks at paragraph 30 and over the page at the subparagraphs, we see that there was a subcontract price for various work and items, and then one also sees at 13.3 that the rates and price for the work determined was the basis for determining the valuation of additional work or a similar character. But what that means is that if additional work was commissioned, then there was an agreed structure by which that work would be paid for. Then paragraph 13.4 refers to clause 3 of the JCT as amended, and the claimant was entitled to assign or sublet the contract with the consent of GBBS. Now that's put in a way that at bar school one is taught to plead. One is taught to plead the best possible way of looking at it from the client's perspective. In fact, what the contract provides for is in effect a prohibition on assignment without the consent of GBBS. And I don't suggest that you should need to look at it now, but it's in supplemental bundle 24B, page 118. So this is
on the contract terms. There is in the papers something called relevant contractual terms, which must have been a document that one or other or both parties produced at some stage, which rather, I thought, saved wading through a JCT contract. So unless anybody tells me otherwise, I was going to use that summary.
That's a document produced by my learned friend, I believe. I saw an earlier draft of it. I didn't know it had come to the court, but I've no objection to your
Right,
looking
hasn't
at it.
come to me, I don't think.
It's in my papers, so
Was it loose?
it was loose. Yes, it wasn't in the bundles as such. So well, I'm sure between us we can get a copy from my lady.
And as long as clause 3.1 in that document provides the subcontractor shall not, without the prior written consent of the contractor, assign this subcontract or any rights thereunder.
It does. That's exactly what it says.
The word prior being in square brackets. Does anything tell
Yes,
on that?
that does, my lord, because it was added as a result of the document which is in the same supplemental bundle, 23B, page 107.
So there was a list of bespoke amendments. And this document means we don't have to worry about that because we can look at it all in one place.
I will get a copy from my learned friend as to the exact document he's handed up and check. But for my purposes, the only clause I particularly want to
is that one.
Is that clause.
Yeah, I mean, there's also the consent to subletting below it, which
Where the consent is not to be unreasonably delayed or withheld.
Yes,
So,
and that's absolutely.
I mean, that's the only clause I've marked up.
yes, right.
Absolutely.
Thank you.
Okay, thank you.
Back in the particulars of claim, we can then cut on to paragraph 90. So that's page 108, where we see that there is a plea there in relation to an extraordinary meeting of the Solar PV NEDL held on the 27th of October 2011 by NCC and attended by GBBS. It was agreed that the claimant would be employed as the supplier for the additional 300 houses to be completed before the end of March 2012. Now, my lords and my lady, that relates to what the judge called Category 3 claims, and these were claims where there was no formal contract providing for that installation. All that the claimant could do was point to an agreement that had been reached between two other parties, GBBS and NCC, that the claimant was to be employed to supply an additional 300 houses. So there is no plea in relation to those installations of any contract allowing for those installations to be designed, laboured on, and then supplied as plant and materials, i.e. picking up the wording in paragraph 12.
I'm sorry, what is the Solar PV NEDL?
I'll be correct if I'm wrong. I understand that that is a body either within the NCC or part of the NCC that came to reach a conclusion as to how the NCC, so the Northumberland County Council, should be supplied with these materials.
I see.
How many was it 400 houses that were contracted for definitely in the contract, and then you pointed us to a clause which then enabled its terms to be extended to other houses in the future. Is that how it worked?
Yes, my lady. So there's a certain number, and my learned friend talks about 130 odd houses.
No, I think 130 was commercial.
Commercial buildings.
Commercial
yes.
buildings, I'm sorry, yes.
Yes, and again, the summary we have at the top of the third page refers to the phase 1 of the PV installations,
Yes.
relating to 400 dwellings and 130 commercial
Yes,
buildings.
I'm grateful. I'm grateful. Yes, that's my understanding.
But was there anything in the original contract which provided a mechanism whereby additional houses or additional work would be brought within the contract or brought under the contract terms?
My understanding is that's the clauses referred to in paragraph 13.3. So clause 5.6.1.1 and 5.6.1.2. So those provisions allowed for the inclusion of additional work with a price that was to be determined by reference to what had already been agreed.
Right, but it didn't say anything more specific about notification of one side or the other, or how it was to be done.
Not that I'm aware of.
And there was no sort of option or right to require further buildings to be added to the initial tranches, presumably. It was
Not
a matter of agreement between the parties. But if they did agree, then those two clauses would be relevant because they would determine the prices.
Yes,
Is that right?
my understanding of the case is, at its highest, there was an agreement as to what price might be used for any additional work. But the parties were then to decide whether or not there was any additional work,
Yes,
and
I
would then
follow.
have to contract.
So there was no obligation on either side for additional work to be taken on board.
That's my understanding.
Thank you.
So then, continuing in the particulars, we see that paragraph 20 in the circumstances it's pleaded, the claimant had the benefit of an enforceable contract with GBBS under which GBBS was obliged to pay the contract price for the contracted works and was obliged to pay a price calculated on the same basis for the additional 300 houses in phase 1.2, which had been decided by NCC and GBBS to order from the claimant.
Well, and you say that's eliding together a number of different things.
And what one then sees as the plea at paragraph 21 is the benefit of the contract and or the goodwill in that part of the claimant's business, which was concerned with providing goods and services under the contract, was and or presumably is a possession and or were possessions within the meaning of A1P1. In particular, the contract had a significant economic value, namely the capitalised value of the expected future cash flow generated by the contract, and such economic value could have been realised by an assignment or subletting of the contract, whether at law or in equity, and or a sale of that part of the business as a going concern, which was concerned with providing goods and services under the contract. So what is very specifically said is that there is an A1P1 possession. The A1P1 possession in particular is the contract with its capitalised value of the expected future cash flows. And it said that that economic value could be realised by a process of either assignment or subletting, whether at law or in equity, or a sale of the business as a going concern. And that is what we say falls foul of the approach that, in the cases that I'll show you in a moment. But I'll come to look at the issue on possessions in due course. What instead at this stage I want to do is just look at what the claimant did after the October 2011 proposal was issued. And we see in the particulars of claim the proposal being issued, paragraphs 22 to 25, and then we see paragraph 26 and following what happens, and in short what happens is Northumberland County Council and GBBS discuss the impact of the proposal on the project, and that's really 26 to 30. And then there's then a variation of the subcontract between GBBS and the claimant, and that's from paragraph 31 and following. I'm particularly interested in paragraph 33, which shows the nature of the variation that occurred, or is said to have occurred. What's said to have occurred is that Mr. Richardson of Solaria maintains that he agreed to reduce the price of the panels from 135 per watt to 110 per watt, importantly conditional on the government's proposals coming to fruition in their current form. So, pausing there, what do we have? We have a contract for the supply of certain goods and services. That contract remains in force following the proposal, but on C's case, on the claimant's case, the appellant's case, it was varied to allow for a price flex which would only operate in the event that a certain eventuality occurred. That certain eventuality was the government's proposals coming to fruition in their current form, something which in fact did not happen. Now, as a matter of principle, therefore, it's difficult to see how the proposal can be said to have interfered with the contract in such a way as to lead to loss. The proposal wasn't implemented. As a result, the claimant had a right to be paid in full under its existing contract.
For the phase one houses and commercial.
Absolutely, mate. And what appears to have happened is that GBBS made a commercial decision not to honour the contract as varied, and it was its failure to pay which caused a loss. And that is the novus actus interveniens argument that the judge refers to in his judgment. It's not one of the bases on which we sought summary judgment, but put in that way, in my submission, one can see why it is a powerful point to take. That said, the judge did approach the question of limitation on the basis that the claimant had a good claim. And my learned friend, in his submissions this morning, accepted that, I think, but that goes a long way, because that goes a long way to undermining much of the challenge that he then wants to bring in relation to limitation. But as I said, I'll come to limitation in a moment. What I do want then to show the court is what Solaria then did. And Solaria then looked elsewhere for a financial remedy. And one sees that from paragraphs 35 and following of the particulars. So rather than joining a bandwagon of claims against the department, Solaria did three things, and I'll just outline them and then show my lady where those are in the judgment. First, it continued to supply GBBS at the original rate.
The 135.
Yes, my lady. But it continued to supply GBBS in any event. Second, later, it fell into a dispute with GBBS about payment and brought proceedings. Third, and much later, it pursued NCC for money. So the department is the tail end Charlie. We are the fourth port of call, in effect. And if one just looks at the particulars, paragraph 35, there you see, in accordance with the subcontract, Solaria issued the invoice for panels delivered to GBBS on the 8th of December 2011 in the sum of 225,318 and 75 pence. Since the panels have been delivered and signed for prior to the 11th of December 2011, then irrespective of any variation, the original price of 135 applied. Solaria simultaneously issued a credit note to refund 10% of the price for the reason stated at paragraph 16 above. That was because the what goes back to paragraph 16, that relates to accounting purposes, would invoice for the full price of each delivery together with a separate credit note, refunding 10% to reflect prior payment. Then we see at paragraph 37, the judgment was just admitting. And then we can go on to paragraph 40, where we see what is said by GBBS. Mr. McGovern says, unless Solaria agreed to apply 110 to the 8th December 2011 delivery, GBBS did not pay for any of the goods supplied at all, even though he was aware that the reduced rate was conditioned upon an eligibility date of 12th of December 2011. He insisted that all of the subsequent invoices should be at the reduced rate, otherwise they would not be paid. And then if one goes on to 42, the claimant continued to deliver photovoltaic panels to GBS between January 2012 and July 2012, and there all were invoiced at the 110 rate on account of the price. So the claimant continues to make delivery, despite the fact that there's a dispute as to how much should be charged. But in any event, those supplies continue between January 2012 and July 2012. The new rate...
Invoiced at the lower rate, despite the condition not having been satisfied.
Yes, my lord. Yeah. And that's also despite the fact that the change, the actual modification, comes into effect on the 2nd of March. So the parties continue to function perfectly effectively without any form of concern. Then, my lord and my lady...
Was the amount of the reduction in the tariff that was actually brought into effect from the 2nd of March the same as had been proposed?
It was.
So the economics were the same, it was just the date, yes.
And from the department's perspective, the economics were obviously very different, because they would have made savings if the reference date had been much earlier.
No, I'm just thinking about the 135, 110 logic.
Absolutely. And in this context, the economics were identical. Then, if the court can go to paragraph 45, what one sees is that the claimant waits until July 2013 to issue invoice for the goods delivered between January 2012 and July 2012, and then waits another year before issuing a claim against GBBS. One sees that from paragraph 46. So the claimant was not getting on with matters against GBBS. It was simply seeking to...
Well, what were the contractual terms about promptness of payment?
Melanie, off the top of my head, I can't help you, but I'm quite sure that period of time was not permissible.
Right.
Indeed, the relationship's seen that the invoice that was issued for the plea is paragraph 35, in accordance with the subcontract on the 14th of December 2011, Solaria issued an invoice for panels delivered on the 8th of December 2011. So there's certainly no objection to raising an invoice promptly. Moreover, we would submit that there's certainly no reason contended for by Solaria as to why they then delayed until August 2014 to make a claim against GBBS. And the important thing to notice there is that the claim is commenced only against GBBS. No suggestion to the department that there was any claim that it wanted to bring. No pursuit of any claim. Those proceedings were then stayed on the 9th of March 2015 as a result of GBBS going into administration. And then we see at paragraph 47 that 3 years later, a settlement is reached with NCC in relation to the PV panels that the NCC had retained. Now, my own friend in his submissions this morning sought to suggest that these steps were seen to be by way of mitigation in relation to losses that were caused to the claimant by the proposal. We wouldn't accept that. We would say that that is very much a matter of causation. But for limitation purposes, it doesn't matter. What is clear is that there's going to be a need for evidence in relation to all these decisions and all these steps. Evidence from the claimant, evidence from GBBS, evidence from NCC. So that's how the claimant dealt with other third parties. As the court knows, the claim was first intimated against the department in a letter sent on the 21st of December 2016. And that is in Supplemental Bundle 5, page 44. No attempt was made in that letter to deal with limitation issues. The court wants to take up that letter. It's, as I said, Supplemental Bundle tab 5, page 44. And background will be familiar to the court. If one goes to page 45, one sees what the loss and damage was said to be. The goodwill of the business represented by the capitalised expected profit on the goods which was anticipated would be supplied at the contract price before the end of March 2012. The response from the department is that's the 21st of December, my lady, 2016. And then if one goes to tab 6, one sees there the department's response. And one can pick it up in between the two hole punches. Paragraph beginning section 7.5. Section 7.5 of the ECHR provides that proceedings must be brought before the end of the period of 1 year, beginning with the date on which the act complained of took place, i.e. within 1 year of the 31st of October 2011. Your proposed claim is out of time. Your letter makes no case for an extension of the 1 year period. Then, in the circumstance we don't address the substance of the allegations, then there is an issue. They draw the claimant's attention to the fact of the trial, listed to commence in January 2018. And then, final paragraph, if any claim is issued, our client will apply for a strikeout on the grounds it's out of time, and in the event that the court extends the limitation period, any determination of the substantive points raised by the claim should be stayed until after judgment in the current Brea litigation. So the Department was making very clear that it would take exactly the point that we are taking now in front of this court in the event that a claim was issued. A proper response to a letter like that is to issue proceedings.
So that last paragraph is saying that effectively the stay would be conditional on the department losing the strikeout.
Absolutely, my lord. So it's not that the department just saying, well, issue, stay and wait.
No.
The department would apply to strike out and would run precisely the type of arguments that I'm running now, albeit at a time where the trial was had not yet taken place. One can anticipate the type of arguments that the department would run. It's too late, we need expert evidence, we need disclosure, we need witness statements, all of that in a year, and the department is also busy fighting 20 other claims brought by 20 other claimants, which the department has a limited legal ability to deal with, and will put the department under too much pressure to do so. And those arguments could then have been determined. But that's not what the claimant did. The claimant did not then seek to issue proceedings. What the claimant did instead was 2 weeks later, one sees this from page 49.
I suppose just before you go on, I suppose if on that basis, if the claim had been not struck out, the department would have said, well, we can't be ready to deal with that in the trial that was coming up in January 2018, in which case there would have been the risk of inconsistent findings, which my lord, not I, but my lord is very familiar with, having heard an argument last week.
And that would indeed be another argument that if I'd been doing it or had been...
That's what somebody would have raised.
Someone would have raised that, exactly
yeah.
that type of argument.
Yeah. But anyway, you say the right response to this letter would have been to issue proceedings.
Absolutely. And that would then allow the court to control the way in which these proceedings would be managed. And it would be for the court then to decide whether it was equitable to extend time in the particular circumstances where this claim was now being asserted. The court would also then have been able to decide whether or not to stay those proceedings, or whether to require the claimant to catch up and to require the department to deal with that catch-up. The department's position was that it should be stayed, but that may well have been not what the claimant would have wanted to argue for.
Where by catch-up you mean they would be encompassed in the Brea proceeding?
Yes, madam. Could they then be ready for the Brea proceedings in a year's time? And then, if the court goes, please, to same bundle, tab 7, you see at page 49 the response.
My tabbing and page numbering seems to be different. So
Sorry,
what's
page
the date
49.
of what's the date of the letter?
The letter dated the 17th of February 2017. From Capital Law.
Yeah.
So over 2 weeks pass, and a dispute then arises in relation to limitation, where, for example, if one looks at the second paragraph under the heading limitation, one sees words that your lordships and my lady will be very familiar with. The 1 year period provided under section 7.5 is not appropriate for such claims, where if it were a claim in tort, our client would have 6 years to bring a claim and would still be in a position to commence proceedings without any risk of a limitation defence. The 1 year period reflects the fact that there may be cases where expedition is required for administrative convenience, but that is not a consideration in this case, given the circumstances of our claimant, of our client. So there's a positive assertion that this is just a tort claim. It's submissions made similarly by my own friend during the course of this morning But with respect, that is just not right. This is a statutory claim where Parliament has provided under section 7.5a for a one-year period. It is also provided under 7.5b for the possibility of the court where it is equitable to do so, to extend the time. It is not and should not be understood as being, where the claim is just for damages, a provision which means that 6 years is the normal amount of time that can be waited on before bringing a claim.
I suppose it is a tort claim in the sense that it could be characterised as a claim for breach of statutory duty or something of that nature. But in that case, it's anyway subject to the express time limits laid down in the 1998 Act.
Absolutely not. And what's then said is that there's no expedition required in the same paragraph. But the overriding objective requires the parties to act promptly. Indeed, the very equitable principles that my learned friend seeks to rely on make it clear that a party cannot rest on his or her rights. But that is exactly what this claimant has done. What they asked for, rather than actually issuing the claim, was firstly, we'll see this at page 50, sorry, maybe the second page of the letter.
Yeah.
In the substantive paragraph just by the second hole punch above the word stay, is that the assertion it would be disproportionate to deny our client the compensation to which it's entitled for loss, which was consequent on the unlawful actions of your client. So effectively just saying, well, the merits of our case are such that we must have a remedy. In many ways, my friend has sought this morning to say exactly the same thing. Well, we've got a claim. Parliament has recognised that these claims exist. We shouldn't be cheated out of our claim, and it would be inequitable for us to be cheated out of it. But we would submit that that's not the proper analysis. It's not about cheating someone out of the claim. The proper analysis is to say Parliament has provided that a party may obtain the right to bring a claim outside the one-year period, but only where it is equitable in all the circumstances. And so what's asked is whether the department would waive its right to rely upon an illimitation defence, and that was not agreed. Then there's a suggestion of a stay, or dealing with the question of stay. And over the page, the paragraph just before standstill agreement, we see no reason why our client should be deprived of its right to bring and prosecute its legitimate claim. If we're incorrect in our understanding of the purpose of the trial, will you please set out full particulars to demonstrate why you consider it's appropriate for our client's claim to be subject to a stay, and what risks, if any, would be run by addressing the claim of our client at a later stage?
At this stage.
At this stage. But then standstill agreement, then there's a request for a standstill agreement. And what then happens is the parties agree a standstill agreement. So standstill agreement suggested in February 2017, and the agreement is in fact reached in May 2017, in principle, and one sees that from the email at tab 9, page 54, which for my lady, I'm afraid I don't know what page.
Well, I seem to be 20 pages behind. So.
And the standstill agreement itself is at page 56. And what that provided for was materially at clause 2.1.1, page 58, which is that time would be suspended from the 21st of December 2016 until the earlier of any of the dates or events referred to in paragraph 23. And then paragraph or clause 2.3, the suspension of time under this agreement shall continue in force until the earlier of 30 days after the service by any party of a notice, stating that the running of time to recommence. In fact, So the agreement was concluded on the 21st of December 2017, but with a degree of retrospectivity, which was, in my submission, generous of the department to provide. But in any event, notice was given on the 30th of January 2018, and one sees that from the document at page 62. The result of the agreement was that time started to run on the 1st of March 2018. But in fact, there was then no activity from the claimant until...
Sorry, let me just get this right. The standstill agreement is agreed on the 21st of November 2017.
Yes, my lord.
But it's retrospective for 11 months.
Yes, my lord.
And then 2 months later, this notice is given that it's come to an end.
Absolutely, my lord.
I once had to do a judgment where I had to pick through standstill agreements and whether they covered the entire period. They are...
Yes.
They don't make life very
I thought you
easy.
said the agreement was reached in principle in May.
It was, my lady, but then the parties had to agree the terms of the
Oh.
document,
And that took more
and that took
till
more
November.
time.
So it was a kind of agreement to agree, which
Yes.
bore fruit in November, but was then backdated to December 2016. So the actual period, if I got this right, of the standstill was in effect from the 21st of December 2016 to the 1st of March 2018.
Absolutely.
In other words, a period of 1 year and 3 months and a week.
Absolutely. Yeah. But despite the standstill agreement having started to run on the 1st of March 2018, it's only on the 20th of July 2018 that there is any activity from the claimant. One sees that from the document at page 64 of the book. Then eventually, proceedings are actually issued on the 21st.
64.
64, my lord, yes. 53 is the other numbering, it's tab 12.
Yeah, right. And then that's a letter before action.
My lord, yes. Even though a letter before action obviously already been written, as we've seen on the 21st of December 2016.
Yeah.
There is then further correspondence, which it's in the bundle, but I don't intend to take your lordship's
No.
my lady through, because one can cut to the end of the period, which is that the proceedings are issued on the 21st of December 2018. And the reference to that is Core Bundle 12, page 102, which is the claim form. So there has been, taking account of the standstill agreement, 4 years and 11 months of delay. Moreover, there was also not only delay before the standstill agreement, but there was also delay after it. So, notice
So the
having
4
been
years and
given
11 months is runs from when?
from the proposal. Sorry, no, 1 year after at the end of the limitation, the primary limitation period.
Right. So from let me just so I understand where that period is. So that's 1 year after. What's the date?
The date is the exact date is the 9th of November. So 31st of October 2011,
Sorry, what?
which is the
What
date of
date
the
of
proposal.
20.
The 31st of October 2011.
So 1 year after the 31st of October, which was the proposal that was found to be unlawful. So that's the 31st of October 2012. And there's then that period until the 21st of December 2016.
Yes.
So that's 4 years and 2 months broadly. And then the standstill agreement covers you until the 1st of March 18, and then there's from the 1st of March 18 to the 21st of December 18, which is another 9 months.
So that's 4 years, 7 months after the primary quotation.
So that's your 4 years, 11 months.
So there were periods we would submit of extended delay, both before the standstill agreement came into effect and after it's expired.
Yeah.
If we could just go back very briefly to the particulars of claim. Which in the core bundle tab 12. Could you please turn to page 115. What the court has there, paragraph 49.6, is the claim that's being advanced. So it's 114, it's actually picking it up first, paragraph 49. As a result of the publication of the proposal, the claimant has foreseeably suffered loss and damage, namely, the capitalised value of the expected future cash flow generated by the contract which, but for the proposal, the claimant would have received under the subcontract as follows, and then sets out a number of different items. But for our purposes, we can look at 49.6, where there are 3 categories, and those are the 3 categories that the judge refers to in his judgment. So category 1 is the difference between the £1.10 per watt rate and the £1.35 per watt rate for deliveries of PV panels under the subcontract for the 31st of March 2012. We're pausing there. The 31st of March 2012 is the wrong date in any event, because it's the 2nd of March, the date of the actual proposal. But one sees that what's being sought is the capital value of
the 2nd of March is the date on which the lawful thing was implemented.
Absolutely,
yes.
my lady. So the 31st of March, we would submit, can't be the right date in any event. But in any event, what that shows is what's being sought is the capitalised value of that expected future cash flow. Then category 2 is for a certain sum for the PV panels that would have been made before the 31st of March 2012, but for the proposal. So that delivery is not in fact made. And then category 3 is the loss of profit on goods supplied for an additional 179 houses per the attached calculation of lost profits marked A. And A is at page 120. And it has been the department's understanding that this category 3 relates to the additional houses, the 400 odd, which in fact became 179 houses, and that's the nature of the claim that's made in respect of those houses.
300.
This 300 was what had been said would be done, but in fact it's only 179 is the loss of profit.
Sorry, you said 400. I'm getting confused.
Oh, sorry.
The 400 was the original.
Yes.
Yeah, phase 1.
So this is phase 2.
This is phase 2.
Thank you.
So what was thought to going to be the 300 plus 130, but in fact only turned out to be 179 houses. Is that what you're saying?
No, maybe. I understand this to be a claim in respect of the phase 1.2 element. So the additional...
It wasn't an additional 300, but it was an additional 179.
Exactly.
Yeah.
So, my lady, that's what I want to say about the facts. And now if I can turn to the law and the grounds of appeal. So first, possessions. What I'll deal with I'll take my submissions broadly in three parts. I'll look at the judge's findings, then the applicable legal and factual framework, and then briefly the grounds. So on possessions, A1P1, the judge's findings are set out in detail in paragraphs 19 to 66 of his judgment.
Paragraphs 19 to 66.
19 to 66, yes.
Yeah.
And in those paragraphs, he identified the relevant alleged possessions, and then he addressed the law and facts. And I'd start by my submission by saying the identification and classification of an A1P1 possession is never easy. We submit that there are no identifiable flaws in the judge's analysis. And it is not easy, because as common law lawyers, we come to look at these concepts outside the realm of Strasbourg. What the judge, we submit, quite properly did was look in detail at the authorities decided in this jurisdiction in relation to precisely that issue. He looked at Breyer, both at first instance and in the Court of Appeal. He looked at Murangaru. He looked at Malik, both of those two cases in the Court of Appeal. And he also looked at Nichols, the judgment of Mr. Kenneth Parker. And he looked at the possessions relied on by the appellant and analysed them by reference to those decisions. And he concluded that the Category 1 and Category 2 claims were not claims for goodwill, in that they were claims for future potential income arising out of a contract.
Hang on, sorry, I'm just getting a note of that. He said in relation to, when you say the Category 1 and 2, you mean by reference to paragraph 49.6?
I do, my lord. Yes.
So he said the Claims Act 49.61 and 2 were what?
Were not claims for goodwill for the purposes of Strasbourg, and they were claims for potential future income arising out of a contract for services that included an anti-assignment and subletting clause. And in respect to Category 3, i.e. the claims arising out of the additional PV panels that were to be designed, installed and supplied as a result of the agreement allegedly reached on the 27th of October 2011, that was a claim for potential future income where there was no binding signed agreement, and therefore a fortiori that could not be a claim for a possession for the purposes of A1P1. I say when your lordships, my lady, go back and read the judgment, that's the conclusion that it's clear the judge reached. What I'd like to do is briefly show you some of the cases just to make good the approach that the judge adopted. And what I'd like to do, if I may, is start with Breyer in the Court of Appeal, because it provides the binding framework for this court, and that's in Authorities Bundle 2, tab 31. I'll come back to look at my Lord Justice Coulson judgment in a moment, but for present purposes we can just start with the Court of Appeal. And I'd like to pick it up, please, at paragraph 22, which is at page 4569. And so At 22, the court summarises the judgment below. Picking it up in 22, a possession within the meaning of A1P1 does not include a right to acquire possessions, and a mere prospective loss of future income is not a possession. And then 23, the following principles can be extracted from the case law. 1, loss of future income is not a possession protected by A1P1. Loss of marketable goodwill may be a possession protected by A1P1. A number of factors may point towards the loss being goodwill rather than the capacity to earn future profits. These include marketability and whether the accounts and arrangements of the claimant are organised in such a way as to allow for future cash flows to be capitalised. Goodwill may be a possession if it's been built up in the past and has a present-day value, as distinct from something which is only referable to events which may or may not happen in the future. And thus, if there is interference which causes a loss of marketable goodwill at the time of the interference, and if that can be capitalised, then it's prima facie protected by A1P1. And then where solar panels were installed and commissioned pursuant to contracts and associated leases between customers and installers, the contracts constituted marketable goodwill. So one sees that the court is adopting the goodwill analysis for the purposes of identifying what the contracts actually mean. The reference there to associated leases is a reference to the fact that some of these contracts provided for a lease to be granted by the homeowner to the supplier so as to install the solar PV panels and then to divide up the revenue that would then be accrued. But what we see is here the Court of Appeal is adopting an analysis which has the contracts as being themselves marketable goodwill. And the application of the principles was best demonstrated by reference to paragraph 39 of Holmeson's statement of case, under the heading Goodwill in Holmeson's Business. This identified 5 categories of potential or actual contracts as follows, and then set out a number of different contracts. The difference being, for example, in little 1, leases which have been requested and sent to customers. Little 2, leases that have been signed by customers. Little 3, leases that have been signed by customers and relevant Homesun subsidiary company, but the solar PV panels had not yet been installed and commissioned. Little 4, they've been installed, commissioned, following as defined by the 2010 order. Little 5, they've been installed, commissioned, an application made to the FIT licensee as required by the 2010 order through their subsidiaries to the benefit of FIT income stream at the 43.3 rate. So 25, the judge said that the contracts identified at 4 and 5 constitute an element of Homesun's marketable goodwill, but they were not relevant to the claim made in these proceedings because the installation contracts were unaffected by the proposal. Contracts referred to in 3 were prima facie an element of the marketable goodwill of Homesun's business. So one looks at 3, just to remember what it is. It's leases have been signed by the customer and by the supplier, but the solar PV systems had not yet been installed and commissioned.
So do we take that to mean they are binding obligations that have been entered into?
Yes, my lady. Binding obligations to install and
yeah,
commission.
so 3, 4 and 5 are all binding obligations, and the 1, 2 and 3 are all something short of that.
1 and 2 are something short.
Yes, sorry.
And 3 is binding. And the analysis that the court is adopting is that that is part of the marketable goodwill of Homesun. So it's looking at the issue of possession through the mechanics of marketable goodwill. And then, on the assumption that this goodwill could be capitalised and therefore represented as marketable goodwill at the date of present, it seems to me that this goodwill is prima facie protected as an asset and therefore constitutes a possession under A1P1. And then 26, the possible future contracts identified in 1 were not a possession under A1P1. They were much too speculative to represent an element of the marketable goodwill in the Homesun business. They were a hope and no more. And then the leases in 2 were the most difficult to classify Some of them might be capable of being treated as concluded contracts, but in general, to the extent these proposed contracts have not been concluded and were therefore not legally binding, they had more in common with a claim for loss of future income than a claim for loss of marketable goodwill. Accordingly, I conclude that the prima facie, those potential future contracts do not give rise to a recoverable claim. What the court...
So you assume that in 2, it's been signed by the customer. All that remains is for the company to sign it, for it then to plop into the 3rd category.
Absolutely, my lady. But
the customer has agreed to be bound, and all that remains is for the counterparty.
But that is treated not marketable goodwill for the purposes of an A1P1 possession.
Subject to the facts.
Subject to the facts, absolutely.
Because the qualification was that any issue of fact had to be resolved at a later date. So if it hadn't been signed, but there'd been some email or something saying, thank you very much for your signed thing, we're entirely happy with it, we'll get back to you in a few days, then that might be effectively 3 rather than 1.
Absolutely. Then the court continues to look at paragraphs 28 and 29 and 30 at some of the cases that my learned friend has referred to. And given the time, I won't go through those paragraphs. Your Lordship's quite able to my lady, quite able to read them to yourselves. It also cites Batalam in paragraph 30 as well. Then at paragraph 32, the court looks at the Strasbourg jurisprudence through the English judge's perspective, looks at the judgment in Nichols, and there the facts where the claimants had previously obtained permission to work as door supervisors, each of them was refused a license, and one picks this up over the page at 4572. They committed a relevant criminal offence. They claimed that their refusal was an infringement of their A1P1 rights. The judge looks at the form of possessions, and the Court of Appeal adopts what is said there. And again, I don't intend to read it to the court. I would just particularly emphasise that it is a goodwill analysis based on the expectation of future income, not being a possession. The loss of livelihood alone is not sufficient. And if one goes to paragraph 72, one sees that goodwill in this context, so paragraph 72 of the quotation, and so just before F on page 4572, it seems to me that goodwill in this context is not being used in the technical accounting sense of the difference between the cost of the acquired entity and the aggregate of the fair values of that entity's identifiable assets and liabilities. Goodwill is there used to fill a gap in the balance sheet that would otherwise arise. It appears that goodwill is being used rather in the economic sense of the capitalised value of a business or part of a business as a going concern, which according to modern theory of corporate finance is best understood as the expected free future cash flows of the weighted of the business discounted to a present value at an appropriate rate after tax. Then there is, of course, a connection with the accountancy concept of goodwill, but what the court is making clear, and that is language that the claimant itself picks up in its particulars of claim, is the economic sense of the capitalised value of the business.
But aren't they then talking about just the quantification of the loss that you've suffered as a result of the interference, rather than saying that a contract can only be a possession if you can describe it as marketable goodwill? Because if I'm not running a business and I have a contract, can that not then be a possession because I don't have goodwill as an individual that I can sell or have, but I have a contract, I have rights under a contract. Can that be a P1 possession or not?
I'm saying no. The goodwill analysis that is being set out here is indicative of an approach that looks to see what is the economic value of the asset and to determine whether or not that asset has an economic value.
But surely it's not the only way of looking at it, is it? I mean, I can't believe that the jurisdiction has become so sort of ossified that one has to adopt this rather mysterious, almost mystical goodwill analysis in order to turn it into a possession for the purposes of a provision which is meant to apply broadly across the board. I mean, we all know, for example, social security benefits. Everyone agrees they're possessions without getting into great complications about goodwill or anything else.
But in this case,
yes, but
but
why is it not enough just to say, here we have a valuable commercial contract? I mean, full stop, frankly. What's wrong with that?
I would say, on the basis of the goodwill analysis adopted in these cases,
Well, that's just a huge complication. Why do we need it?
well, one needs it to keep a proper scope to the nature of any form of A1P1 claim. And what is clear is that one needs to analyse the nature of the possession to then work out whether or not it qualifies.
But we have an asset in the form of a shows in action. I mean, the contractual rights under the existing contract.
Well, my lord, shows in action is a dangerous
All right, well, it's
concept to
it's
use.
it's a form of property.
Well, my lord, one analyses what is this? It is actually, what is this contract?
Yeah.
The contract, it is an ability on one party to obtain money if it designs, installs,
Yes.
and undertakes work.
But why then isn't the loss just the loss of
Loss
the
of profit.
profit?
Yes.
But why do you, I mean, you know, obviously you can't claim from the government the price of the contract if you've not actually done all the work, and you may, you know, the chopper may come down, you may have done the work and provided the panels on some, in which case you would say that your loss is more than it is in relation to houses which were contracted for but where you haven't actually done any work yet. So you haven't incurred the cost of the panels and the labour and transport or whatever. But I don't understand why it's got to be expressed as goodwill. I don't find that helpful. Let alone marketable goodwill, whatever that means.
I see your ladyship's concern, and I think the answer that I would offer is this: the claim is put forward on the basis of the capitalised value of the asset.
Yes, that's how they quantify their loss arising from the interference. They could have done it by profit, they could have done it, maybe it would have been simpler and we would have avoided all this, but they did it, maybe looking at Brer, by using this phrase. But I don't at the moment see that that's anything to do with the nature of the possession. It's more connected with what loss have they suffered as a result of the interference with these particular contractual rights.
And I think my answer would be, when one looks at Murungaru in particular, one sees that one needs to analyse out each contract to work out whether or not it satisfies the indicia of a possession. And one of the indicia that is identified in Murungaru is indeed assignability.
Yes, but they didn't say, well, Mr. Murungaru, you are an individual, or you're not running a business, presumably, of receiving medical treatment, so you don't have any, this contract doesn't add to your goodwill, and the only possession that can arise from a contract is marketable goodwill. It wasn't knocked out on that basis. He was an individual, not running a business, and yet there was still a debate about whether the contract of which he had the benefit could be a possession. And then they said, well, no, it can't because it doesn't have any economic value. But we don't have that problem here. These contracts clearly had economic value without having to be converted into something.
I think that's where we would conceptually differ with the leadership, because what we would say is they have a future income stream, potentially, if certain things are done. That that's an
Sorry, can I
entitlement.
just come back one more time? They have a future income stream in the terms of the payment of the price, if that's how it pans out. But every contract has an alternative potential income stream of damages if actually performance doesn't take place because of a breach by the other party. So every contract you go into has those two alternative potential income streams, either of which can have been interfered with by the government, depending on at what stage you've got with performing the contract, at the point that it collapses because of what the government's done.
I appreciate that one can talk about interference with things that people might want to do, but in our submission what we'd say is one needs to look just at what is the nature of the possession, separate from the question of interference, and what we would submit that one sees in both Nichols and also in Breyer is a goodwill analysis in relation to a contract such as this, and where there is no such goodwill such as this, then there's no A1P1 possession. We say here there is no marketable goodwill because there is no right to assign, there's no right to sublet without consent, and to then try and put that bundle of rights into a possession context is, we submit, not in accordance with Breyer, and it's not in accordance with the Murunguru approach. Perhaps I could just show the court that decision.
Yeah, before you do that, surely there is absolutely radical distinction between cases on the margins, like Murunguru, where it wouldn't, frankly, cross anybody's mind thinking of personal rights of that nature as being a possession, and contractual commercial contracts of the type we're dealing with here, where you have vested rights under a contract which has been made, and which, as my lady has said, if the contract is performed, will give rise to the payment of the price, and if it is breached, will give rise to a secondary obligation to pay damages instead. And those rights are there. They're vested, to use a sort of English law phrase. That's not remotely comparable to somebody coming to this country looking for medical treatment from his favourite Harley Street practitioner.
I see that, my Lord Wood, and I appreciate the distinction that one needs to look at each individual contract to work out what is the nature of the right, what are the nature of the rights, and can that be constituted as a possession. We would say here, one can't get to the position of saying it is an A1P1 possession, effectively for the reasons I've identified, because of the non-assignability, because of the non-transmissibility. My strong suspicion, though, is that I'm to some extent going to be banging my head against a bit of a brick wall. I've heard the way the argument went this morning. Yes. And I'm not sure in reality whether just repeating that submission time and time again and showing your lordships and my lady Murunguru in any detail is actually going to change the court's mind.
Well, I think one of the difficulties is that the jurisprudence in this area, when Lord Bingham says he doesn't find it easy, then I'm very happy to agree with Lord Bingham and have nothing to add. And a lot of it is because of this dancing on the end of a pin between loss of future income, which you can't have, a marketable goodwill that you can. And I think that my lady is right, again from recollection, the 5 categories in Homeson, or whoever they were called, that we were looking at in Breyer, was effectively part of how they got to loss. So it may be that you do have to wind back, or we would have to wind back and see, well, actually, where does all this go? And rather, as I put to Mr. Adams this morning, that I personally don't get much from cases about licenses, because this isn't a license, it's a contract. I don't think I particularly get much from Murunguru either. I appreciate there's the indicia, we have all of that well in mind. But as my lord says, this is a rather different case.
Well, what I would then leave the court, I would leave the court with this, if I may. The court could analyse or look further at paragraphs 42 to 49 of Breyer in the Court of Appeal. What the court there does is it looks further at the concept and the distinction between goodwill and future income, and looks at looking at the goodwill of a business at any rate if it is marketable value as having accounting as a possession. But my feeling is that I can argue further on this issue, but particularly given that this was a summary judgment application, I doubt that I'm going to be able to persuade the court.
Well, obviously, we will give it further thought, Mr. Weisselberg, and we would all acknowledge this is a difficult area, but sometimes it's a question of not losing sight of the wood for the trees. And I think at the moment we're taking, or at least I'm inclined to take the view that this is a kind of wood, not a tree case. It's just a really big, very obvious reason why this is a possession. And of course we will reflect on that, bearing in mind that equally we are of course bound by whatever are the principles stated in the Court of Appeal authorities we've been referred to.
I'm very grateful.
Thank you very much.
What I then do is go on to limitation.
Yes.
And in relation to limitation, we submit that the judge's findings in this context are very full, very clear. There is no disclosable, discernible misdirection of law. What the judge did was to decide first whether it was appropriate to determine a limitation defence on a summary basis. And he did so fully and carefully in his judgment, paragraph 68. And we submit he rightly held at paragraph 71 that limitation defences could be appropriate for summary judgment. He made that subject to a proviso, which is necessary both for this particular statute and any limitation, that there was not further material evidence that might reasonably be expected to be available at trial. We submit there was no fault whatsoever in the directions that he gave himself. My Lady Justice Rose asked my own friend whether there were any circumstances where Section 7.5b application could be dealt with summarily. His first answer was no. Then it was only where no fair trial is possible. In respect, that's just wrong. Wrong for three very clear reasons. First, no authority to support it. Second, it is a clear gloss on the statute. It is clear on the authorities that no gloss is to be permitted. The third reason is that it misunderstands the concept of equitable. Because what my learned friend seeks to do is to shoehorn concepts of equity into that word in circumstances where the word is actually looking at the larger procedural elements in relation to the claim, and it is looking at all the circumstances of the case, not just a narrow equity approach. What the court is required to do, the focus is on the period and the longer period, and whether it is equitable for a longer period, having regard to all the circumstances. So the concept of equitable bites on period, not on anything wider, although all the wider other circumstances need to be taken into account. So we submit there was no misdirection by the judge. Similarly, the way the judge looked at the facts is entirely, or was entirely, unobjectionable. he properly weighed the evidence and reached conclusions that were properly open to him.
And that's quite, what are the relevant paragraphs? There's quite a lot. I mean, I have read it, obviously. There's a lengthy section on these points, isn't it?
It is, my lord. We summarise them in our skeleton argument, paragraph 38. Our skeleton argument is in tab 5. And at paragraph 38. Sorry. So this is, sorry, I'm jumping around. This first point relates to what elements he directed himself in relation to the exercise of his discretion.
Yeah.
And one sees that in paragraph 38 and the sub-paragraphs there. So, plain from the wording that it creates a primary limitation period of 1 year. B, the burden of persuading the court to allow a claim to be brought outside the primary 1 year limitation period rests with the claimant. The proper approach of the court is not to put a gloss on the statutory language, but to consider all the relevant factors. And the relevant factors may include the factors listed in section 33. And E, so far as the length of delay is concerned, the court's entitled to have regard to the fact that the primary limitation period of just 1 year is a clear indication that claims are to be brought promptly. And then from paragraphs 39 and following, we identify the particular points that the judge weighed up. So 39 did not accept the appellant's submission that the exercise of discretion should be approached whether the court would decide whether to bar a claim on the ground of late cheese. Submission that repeated by my learned friend this morning. I'll come to that in a moment. Then examining the facts of the instant claim, the judge found that the appellant had offered no good reasons for the delay of almost 5 times longer than the one permitted by statute.
Yeah, those are the paragraphs I had in mind. So that's 75 to 79, 83 to 86 and 105.
And then also 107, paragraph 107, which we refer to in paragraph 41, the forensic difficulties that we would face, including the issue of fading memories and the difficulties of disentangling the effect of the proposal from the falling market which ensued as a result of the revised law proposal. The judge considered that it had a strong argument about novus actus and referred to the evidence of Mr. Olson that the litigation had been settled to make efficient use of public resources.
So the novus actus point arose in the context of difficulty or potential difficulty with witnesses.
Absolutely, my lord. And just so your lordship...
On the factual situation, was it the case, allegedly, that GBBS was insisting on only paying 1.10 per watt for panels, even though those panels were installed before the 2nd of March and so were entitled to the higher level of tariff?
That's my understanding.
Right.
But moreover, the conditionality of the 1.35 to 1.10 was subject to
Yes,
12th of December 2011.
Looking at it from GBBS's point of view. So they were saying, even though we're still getting, or NCC is still getting the unmodified feed-in tariff, we're going not to pay you so much for the panels.
Absolutely. That's why we say it's a novus actus.
So on that analysis, a blatant breach of contract by NCCS, in order, for whatever reason, to protect their own position, but not something that can be laid at the door of the department.
Absolutely right. And just so that the court can see how we put it to the judge on this issue, what factors were relevant. Our skeleton argument before the judge is in tab 26 of the supplemental bundle.
I want us to look at that.
Yes, my lord, would you?
Supplemental. What was the final draft?
It's possible that my lady is using it.
Or tell me what it is that was.
It's a supplement. It's the skeleton argument that the defendant used before the judge.
We were blessed with 2 copies of the supplemental bundle.
Yes.
The second one of which, the one with where this is tab 26, arrived yesterday. So
And for once it was slimmer than its predecessor. So that's normally a
Yes.
recommendation in our book. Oh, I'm sorry. Have you got full, 70?
Never mind, don't let me hold
I think my junior could hand up his
Okay.
copy if your lordship is happy to take it.
I think we shouldn't be handing things up in the current.
Oh,
No,
so I'm
that's-
sorry
that
about
was
that.
my-
But,
yes.
Okay. No, don't worry. I will make a note and then.
yeah.
if you go to tab in that the supplemental
Yeah.
bundle, right at the back, if you have a tab 6,
No, I only go up to 5V. Oh, 4. It seems rather bizarre. It's a big contract.
Well, perhaps then the most convenient thing to do is I should just give the court the references.
Yes.
If you can do that, then between us we can solve it.
Exactly.
Right. Thank you very much.
So it's in tab 26.
Yes.
Limitation begins at page 136, where we set out the relevant legal principles, which the judge largely covered. But what I'd like to direct the court's attention particularly is 139 and following.
could you go the paragraph numbers?
Yes, paragraphs 40. So paragraphs 40 to 47 in relation to reasons for delay. Then paragraphs 48 to 51 for prejudice. And paragraphs 52 to 53, which summarise the overall position. Those were submissions that we made to the judge and that the judge largely came to accept. So that's what I say in relation to the approach of the judge. The applicable law and the factual framework. There are 5 relevant cases. Case of Dunn, case of M, case of A, case of Raybone, and the case of Betterment. We say Dunn and M provide the answers for today. My own friend relies on overture extracts from A and submissions and observations in Raybone and Betterment. But we say those don't take him where he wants to get to. In relation to Dunn, starting with Dunn, that's in Authority Bundle 2, tab 19. Pick that up, if I may, at paragraph 30. So, in paragraph 30, Lord Justice Thomas notes that the court should not add to or qualify or put any gloss upon the words equitable having regard to all the circumstances when considering the exercise of the discretion. So it's clear that it's a discretion, it's clear that there shouldn't be a gloss. The words of the subsection mean exactly what they say, and the court should not attempt to rewrite it, accepts that submission. Parliament gave the court a wide discretion. I do not think it would be helpful to list the factors to be taken into account or to state which should have greater weight or less weight. And with respect, that's exactly what my learned friend asks the court to do. The statute requires the court to consider all the circumstances in deciding whether it's equitable to allow a longer period within which to bring the claim. And then if one can cut down to 32, it's desirable to follow a similar approach in relation to the Human Rights Act. That's the approach adopted in Hyman and Rose, not to list the factors or indicate which factor may be more important than another. My own friend repeatedly says, well, mere delay is a factor that should not have any weight at all. We submit that's wrong. That's wrong for the reasons that Lord Justice Thomas gives. It's for the court to examine, in the circumstances of each case, all the relevant factors and then decide whether it's equitable to provide for a longer period. It may be necessary in the circumstances of a particular case to look at objective and subjective factors. Proportionality will generally be taken into account. It's not, in my view, appropriate to say that one particular factor has, as a matter of general approach, a greater weight than others. As I said, that's exactly the approach that my learned friend urges on your lordships, my lady. Then paragraph 33, the three first instance cases cited to us, and the court's already looked at that, looked at where in subparagraph 1, but I'm interested in the quotation from where, top of the page at 744, paragraph 36. So it seems to me that the proper approach, having in mind Lord Justice Wolfe's observation in LBC Croydon, is that an absence of prejudice, so far as section 7.5b is concerned, is a highly material factor, but is not of itself conclusive in favour of an extension of time being granted. So again, that undermines my learned friend's suggestion that the absence of prejudice is sufficient for him to say the claim needs to be brought. As I've shown the court, we don't accept that there's no prejudice. The prejudice is extreme. We've set that out in our skeleton argument for the judge. The judge accepted those submissions. But even if we couldn't show prejudice, then delay still is a relevant consideration. And that's Lord Justice Thomas adopting the judgment of Miss Justice Lindsay in Weir.
One cannot say simply because the defendant suffered no prejudice, ergo there should be an extension of time.
Yes, exactly. And that effectively is his submission. His submission here is, without grappling with the evidence that we put forward on prejudice, which is cited in the skeleton argument contained in Mr. Olson's witness statement, it said, well, this is just a case of mere delay. It's not a case of mere delay. The prejudice is the type of prejudice I've already identified. But forensically now, one would need to look to see what the claimant did, what BBS did, what NCC did. One would also need to look at what the department did. And the department inevitably is in a less good place now, or was when these proceedings were first issued, than it had been when the proceedings were on foot as against the other defendants in the other claimants in Brea. Then anyway, Cameron at 2, invite the court just to read that passage, the quotation from Sir Michael Turner. And in that second extract, we would particularly emphasise the words that begin on the third line of the quotation. In other words, the burden must be on the claimant to prove that there are circumstances which make it equitable why the defendant should not be able to take advantage of the limitation provisions. There are, in my judgment, no circumstances present in this case where it would be appropriate to rule that they should not apply. We would say it's clear that the burden is properly on the claimant in this case to show why it should be able to bring the claim within the period of time has in fact taken to bring the claim. So that's done. If we could then please go to M, which is in the same bundle, tab 22. One starts with paragraph 2, where the judge just sets out, where Justice Rick sets out the nature of the claim. The challenge here in paragraph 3 is that it was meant to be a jurisdiction. Was it jurisdiction or was it procedure? That's not a point that's relevant to us. What one can see then, if one goes on to paragraph, we can actually go straight to paragraph 20.
Because 9 refers to Cameron.
Yes, sorry, yes, absolutely. So 9 does refer. The judge considered the decision of Sir Michael Turner and Cameron, but the court then goes on in 19 to consider what position it should adopt.
Yeah.
And one picks it up at 19, which was the passage that my learned friend showed my lords this morning. But then if one goes to paragraph 20, section 7.5 of the HRI itself recognises by that language that it's dealing with a time limit, just like any limitation time limit, and recognise also that the Limitation Act time limit may be stricter than a time limit imposed by section 7.5 itself. That, it seems to me, is a critical and decisive answer to the submission. And then if one cuts on to 23, it seems to me that there's that difference in language, but there the burden remains, as Mr. Simlet accepts, acknowledging in this respect the decision of Sir Michael Turner and Cameron on the claimant to bring himself within section 7.5b, and that being the case, the burden must be on the normal burden of someone who wishes to persuade the court to adopt an approach to its discretion, which he's advocating. The judge, of course, has to balance all the factors which are in play in the light of all the circumstances of the case. The burden is that of the ordinary civil burden of proof, where matters of fact are an issue, and otherwise it's a burden of persuasion. Quite how the burden of persuasion is discharged by the claimant must ultimately depend not upon the particular form of the statute in question, but on the nature of the factors in play before the court. We, with respect, would say that is exactly the point that Lord Carr is making in the passage in A that I'll come to show at the court in a moment, and that's relied on so heavily by my learned friend. Then, third ground of appeal, which is that the judge has directed himself in principle wrongly in relation to the question of discretion. That really is a submission I've just dealt with. That was given the label as the criteria ground of appeal. The submission at the end of the day was that the onus on the claimant under section 7.5 was lighter than the onus under, for example, section 33 of the Limitation Act, whereas the judge had wrongly directed himself in terms of the onus under section 33. And then no such finding in any event, and then the court goes on to look at Cameron to further extent. No error of principle. And then finally, paragraph 30. And if I could pick it up just halfway down the paragraph, the line beginning in fact. In fact, if anything, the judge made quite light of the fact that it's a striking feature of section 7 that it provides a limitation period of only 1 year, to be strongly contrasted with the much longer period allowed under the Limitation Act, and indeed makes no allowance in the case of a minor. The clear inference is that in the case of such claims against public authorities, perhaps somewhat reflecting the tight 3-month time limit for the purpose of judicial review proceedings, it was considered right that there should be really quite tight limitation periods. The judge made little of that factor. In my judgment, could well have made more. So we would submit that shows that the court is quite entitled to assess the period of delay by reference to the 1-year period that Parliament has provided for claims to be brought effectively as of right. So that's what I say about those two cases, and we say they provide the answer to the appeal in this case. My learned friend, however, relies on A, and if one takes up A, it's in tab 24. One can get 3 points from A, and I'll take those very briefly if I may. The first point is a point that arises out of paragraph 114 of Baroness Hale's judgment. And that was a point debated between my learned friend and my Lord Justice Coulson. equitable must mean fair to each side, there's nothing to suggest that the delay caused any prejudice to the local authority. We accept that equitable must indeed mean fair to each side. The court has to look at equitable concepts for the extension of time. But what we don't say is what my learned friend then sought to suggest is, well, one follows on from that. The note by Baroness Hale that there's no suggestion that delay caused any prejudice. That cannot mean that concepts of equity should just allow any period of delay as long as there's no prejudice. That's the first point. The second point relates to Lord Carr's dictum at paragraph 167. And I effectively have already made my submission in relation to that. There, Lord Carr cites Cameron, and in an obiter section, because he's already decided that the appeal could be dismissed in any event. But in any event, what he says is the burden of establishing, he preferred the approach to approach the question by an open-ended examination of the factors that weigh on either side of the argument, and then reaching a conclusion.
But your submission is that's only putting in another way what Lord Justice Ricks said in M at paragraph 23.
Absolutely. It's no different. It's certainly not saying that there's no burden.
Yeah.
Yes. I guess reflects the obvious fact that judges will normally prefer not to rely on the burden of proof because it's a sort of tiebreaker, and particularly where you have a discretion to exercise. So you begin by weighing up the factors, and it's really only if you find yourself completely stuck at the end of that you might have to have recourse to the ultimate burden on the person asking for the relief claimed.
And the third point I make, and I'm sorry to jump around in the judgments, is to go back to Baroness Hale and to go to paragraph 116, which my learned friend relies on, effectively to say, well, in broad terms, his submission is, as he made clear in his submission this afternoon, that it's a 6-year time limit. It's really a tort claim, and you should just treat it like a tort claim. And so as long as the claim is brought within 6 years, as long as you're not actually seeking to quash something on the basis of convention rights, then you should allow it in. And we submit that that submission is not borne out by the observations of Baroness Hale in paragraph 116. She is there saying that expedition is less obviously necessary in a claim for a declaration in vindication of the claimant's rights upon which nothing else depends, or of a claim of damages. That is true, and we don't seek to disagree with that. But that does not mean that the court can effectively ignore what Parliament has said in relation to timings and just treat all claims for damages under the Human Rights Act as being susceptible, as long as they look a bit like a tort claim, to a 6-year limitation period. Self-evidently, there is a real difference between a claim under the Human Rights Act and a claim in tort. A claim in tort brings a damages entitlement as a matter of entitlement, whereas under the Human Rights Act, damages is a remedy that is available to the court at its discretion. That is clear from the observations of Lord Justice Laws in Faulkner. I don't suggest that your Lordships need to turn it up, it's paragraph 15. But it's also clear that paragraph 15 of the judgment, Authorities Bundle 2, tab 28, which is relied on by my own friend in another context. But it's also clear from section 8 of the Human Rights Act itself, which, as the court was shown this morning, section 8.3 provides that no award of damages is to be made unless, taking account of all the circumstances, the court is satisfied that the award is necessary to afford just satisfaction to the person in whose favour it's made. So there is a discretion there in the court as to whether or not to grant damages, even if a breach of Article 1, Protocol 1 rights has been identified.
So what submission do you get out of that? That
So,
it therefore isn't like a tort claim?
So it's not like a tort claim, absolutely.
That would also mean, I think, the suggestion I threw out this morning that one might classify it as a breach of statutory duty, rather like a Frankovic claim for damages under European Community law. That doesn't really stand up either.
No,
Yeah.
because there is a very particular mechanism
Yes.
by which convention rights have been imported into the UK law,
Yeah.
and challenges can then be
Yeah.
made.
Thank you.
So, my lords, my lady, that's all I say about A. The fourth case that I just need to very briefly deal with is Rayburn, which is in tab 27. And my learned friend relies in particular on paragraph 108 of that judgment. And this is really again in the tort context. And so I think I've made my submission. What one has is a dictum that should not be taken out of its own particular context, i.e. the context of Rayburn. Moreover, the delay was short and readily explicable by the delay in the hospital's own inquiry, and there was no prejudice. So actually, I don't think I need to show you any more of Rayburn than that.
That was a strong case on the facts.
It was, my lord, a very strong case on the facts. So the final case that I think I just need to show you to deal with the points made by my learned friend is Betterment, which is at tab 29. So my friend makes arguments in relation to treat it like a tort claim. He also makes arguments in relation to treat it like late cheese. And we submit that late cheese is not the proper analysis, not least for the reason identified by my Lord Justice Henderson, that late cheese normally only arise where the primary limitation period is not yet expired. But in any event, when one goes to look at the analysis that my learned friend seeks to rely on, which is paragraph 30 of that judgment, one sees that even if these principles were to be applied in this case, it's difficult to see how the claimant can have a proper example, a proper answer. One starts at 30, and the equitable doctrine of late cheese may provide the answer, inaccurately summed up in the Latin tag vigilantibus non dormientibus jura subvenient, and then one sees the quotation. Nothing can call forth this court into activity but conscience, good faith, and reasonable diligence. Where these are wanting, the court is passive and does nothing. And we submit that that is exactly the situation here. The claimant has not, with conscience, good faith, and reasonable diligence, brought this claim. It's certainly not used reasonable diligence, because it has not started the proceedings in the way that it should have done. Moreover, my own friend relies on the concept of late cheese because he says that mere delay is not enough. As I've said, this is not a case of mere delay. We have prejudice here. But even if your lordships and my lady are not with me on prejudice, the delay in this case is unexplained, not properly explained, and is much too long. So that's what I say in relation to the law. If I can beg the court's indulgence just to make 3 quick submissions on the facts. The first submission is that the reasons for delay advanced by the claimant are poor ones. And the timetable that I outlined in my submissions earlier on this afternoon is striking. Panels were delivered until July 2012. That's some months after the change in rate, and then the claimant looked to others to seek to make recoveries. Only in December 2016 was a claim intimated against the department, and then the claim was issued, even taking account of the standstill period, some months later. Why did the claimant delay? In argument, when asked by my lady Justice Rose. And friends suggested that they wanted to wait for the decision in Breyer. That's not the evidence that was put before the judge. The evidence that was put before the judge was that they wanted to continue to pursue GBBS and NCC, and that there would have been cost implications if they had decided to bring a claim against the department if they hadn't pursued the claims against GBBS and NCC. And that's, just for your court's reference, it's paragraph 44 of our skeleton argument below, which is in the supplemental bundle 26, page 139, and that identifies where the evidence is. That's the first reason. And the second reason was that it was not in accordance with the overriding objective. We say those aren't good reasons, and we explain why those are not good reasons in paragraphs 45 to 46.
You know, it could have worked to the department's advantage if if GBBS had not gone into administration and had paid out, and NCC had paid out, then there would have been no loss suffered, and they wouldn't have had to trouble you.
It would have been an advantage, but the question then arises, what's the proper approach to adopt in relation to bringing a claim under the Human Rights Act? And it's at the very least to intimate the claim. No intimation of the claim, so the parties can then decide amongst themselves how best to deal with it.
So on that approach, the really critical period is the one up to when the letter of claim was first intimated in December 2016.
Absolutely.
And even on the most, well, even that involves what have we got then? About 2 years, have we? Over and above the 1 year permitted under paragraph A.
And even then, one would have had difficulties if the claim had been then properly brought. How then would it have been managed properly?
Yes, but one doesn't get to that stage because you didn't even know about it.
Exactly. That's the first submission we make. The reasons are poor. The second submission that we make is that we will suffer prejudice. And I've shown you the skeleton argument where we set out our arguments on that. That's paragraphs 48 to 51 in the skeleton that's before the judge. And the evidence for that is in Mr. Olson's witness statement, paragraphs 33 to 38. And that's in supplemental bundle 2, pages 14 to 60. The third and final submission that we made is that it was quite proper, and is quite proper, for the court to decline to exercise its discretion under section 75B. Now, we identified 6 core reasons to the judge in our skeleton argument. Below, that's paragraph 52, which I showed
Paragraph
52, my lord, which I showed the court a moment ago. These claims are very out of time, no good reason for delay. The claimant was well aware of the judicial review proceedings and the ongoing litigation, but did nothing to intimate a claim. We would suffer prejudice, and the claims are weak, certainly in relation to novus actus interveniens. We say one can see why there are issues there, both by way of prejudice and by way of merits. But we are more than happy for the court to determine this limitation issue on the basis that the claimant has got a good claim. As with all limitation issues, if you don't bring a good claim in time, you lose it. And we say that's exactly what's happened here. And that's why your lordship should dismiss the appeal.
If it's a bad claim, it can be struck out anyway for that reason. So limitation doesn't sort of matter.
Unless the court has any further questions for me, those are my submissions.
Thank you very much indeed, Mr. Weisberg. Yes, Mr. Allens.
My lord, can I just make some very brief submissions on the facts? Because my learned friend, no doubt doing his job, left out some very briefly, my lord. This was essentially a supply contract. The supplies were specified under the contract. instructions could have been given under the contract for additional work at the contractual rates. The decision to purchase the additional 300 houses, decision to install on the additional 300 houses had been taken before the proposal, and that goes to the value of the contract.
Are you saying that's an instruction under the subcontract?
There wasn't an instruction before them.
Sorry?
There wasn't an instruction. There wasn't an instruction before the 31st, but there had been consideration at meetings as to who to employ to make those supplies, and the decision had been taken to employ Solaria to make the supplies, and therefore that was something that had happened in the past as a result of the trade connection with GBBS and NCC that goes to the value of the contract at the date of the proposal. The payment terms under the contract were almost immediate. There were valuations within, I think, 14 days of delivery, and the money effectively came from NCC. So under the contract, as it operated up to the proposal, Solaria was being paid pretty well upon delivery. It was Solaria's case that the reduction in price was conditional. It was GBBS's case in the litigation, as explained in Mr. Jones' statement, that the reduction was unconditional, which was why there was a dispute about it, which ultimately led to litigation. The basic point is, Solaria would never have been in that position if the proposal had not been made. It would not have been exposed to the insolvency risk of GBBS, because it would have been paid as and when the deliveries were made, and it wouldn't have had a dispute with GBBS. In the chronology, it was both parties' decision to wait until after the Breyer trial, as shown in the correspondence, and there was then a pre-action protocol. Excuse me.
Mr. Adams, that's simply not right. It wasn't both parties' decision to wait. It was quite clear from the response from the department that they said, if you start proceedings, we'll seek to strike it out on limitation grounds. That was a choice for the claimant. The claimant chose not to start proceedings. There was a standstill agreement. When that came to an end, the claimant didn't start proceedings.
Well, in the correspondence,
well, we looked at the correspondence.
Yes, excuse me. In the correspondence,
Would you like us to rise for a moment, Mr. Guy? Sorry, Mr. Adams.
In the correspondence, the department said that they would have a stay if we got back in. We suggested the standstill, but that was then agreed by the department. I think they came back in April and suggested that was a sensible suggestion. You don't have a standstill agreement unless both sides agree. And both sides agreed to put the matter back behind the trial, which made obvious sense if there were broad issues to be determined, such as justification. There was then a pre-action protocol process followed before proceedings were issued after the stay was lifted. There's a chronology, I think, at tab 6 in the core bundle that sets out the chronology quite carefully, and Mr. Jones, in his statement, deals with the difficulties they had over the length of the period. We say in particular we don't have to show a good reason for the delay. We have to, it may be relevant what our explanation is. We have a perfectly reasonable explanation for the delay. As far as the prejudice is concerned, my learned friend repeatedly referred to the lawful decision to introduce a new proposal. Of course, if the proposal had not been made in the first place, then we wouldn't have been in the world in which the second proposal was made. And if one's looking at the damages, one would be comparing the hypothetical world in which the proposal was not made with what actually happened. And
So, are you saying that there's no possible counterfactual along the lines that they would have announced on the 31st of October that they were consulting on changing the rates as from the 2nd of March? That
well,
seems to me it is
what I say, that is something that would have to be pleaded in defence by the, that would have to be pleaded in something in defence by the department, who would have to say that we would have had the opportunity to bring the date forward, and they would have to have put forward a lawful basis for that. And we might well say in reply that we had a legitimate expectation that would have made it an abusive process for them to do that. And those are potentially issues that would have to be dealt with at trial. But in any event, assuming it's lawful, supposing nobody goes to the trouble of reliving that battle, the date was brought forward to the 2nd of March. When the date was brought forward to the 12th of December, everybody tried to make as many installations as they could before the 12th. If the price changed on the 2nd of March, it would purely be a factual inquiry as to how the parties would have worked to that date. And it's possible they would not have made all the installations that they could have made before the 31st of March, but it's not obvious why there are any evidential difficulties for the court to decide to work out how many installations would have taken place before the 2nd of March rather than 31st of March. That's a perfectly usual issue that a court would address in private law proceedings, and it's not obvious that the delay has affected that assessment to any extent at all. And the final point that I wish to make, in general terms, on the approach to limitation, is that the court is concerned with issues of principle. Both the Court of Appeal and the Supreme Court have made it very clear that the Section 75B is not to be glossed. Any statements in the cases as to how it should be approached should have the same health warning applied to them as Lord Justice Thomas applied in Dunn. It's dangerous to try and lay down principles, and the Supreme Court has made it clear that they shouldn't be in this case. I'm reminded it was Lord Justice Dillon in Smith and Loosely that reminded us how dangerous it is to lay down principles in this case. It is a matter of principle. It's not a matter of law. This court is not bound by anything that was said in M, which in any event was on the concession of counsel and is inconsistent with subsequent statements of principle in the Supreme Court. And the judge was fundamentally wrong to apply a presumption and then to seek a good reason for the delay. And ultimately, he wasn't in a position to assess in all the circumstances whether there was prejudice, sufficient prejudice, or appropriate prejudice that meant that that the case should not proceed. Unless I can assist your lordships any further.
No, thank you very much, Mr. Adams. Good. Well, thank you both for your interesting arguments on a case which is not without its difficulties. We will take time to consider our judgments and let you have them in the usual way. And we'll invite you to correct any typos and other obvious errors, but not, of course, to re-argue matters, and also to try and agree any consequential matters between yourselves. If you can't, please put in short written submissions, and we will then deal with them on paper, and there will be no need for any attendance, although it seems anyway this judgment, when it is ready, will be handed down remotely, so there will be nothing to attend, even if you wanted to. But thank you all very much indeed, and that concludes today's hearing.